Good morning and welcome to the Court of Appeals. Your panel this morning is Judge McGee from Savannah, Judge Smith from Memphis, and I'm Kenny Armstrong, and I'm from Memphis as well. When you come up to make your argument this morning, be sure to announce your name. I'll also remind you that if you represent the appellant, you can reserve up to 5 minutes for rebuttal, and you'll need to let us know at that time whether or not you want to reserve time for rebuttal, and we'll make a notation on our clock. You'll see the clock has lights. The green light means you have plenty of time to make your argument. If it turns red, that will end your argument unless you get a question from the panel. In that case, you could exceed your time that's allotted. Ms. Ashley, do we have any preliminary matters to take up this morning?
No, Your Honor.
All right, you can call the first case.
Kathryn Summers O'Rourke versus Patrick O'Rourke, Jr.
Good morning, Your Honors.
Morning.
May it please the Court, I'm Martin Sir of the Nashville Bar, and I represent the appellant, Ms. Kathryn Summers O'Rourke. Your Honor, there was a recent decision by this court in the Colley case which gave emphasis to why we're here, and that is the remedial nature of shifting the attorney's fees. That court said that in a context of alimony, that the remedial nature of the Tennessee statute was to be considered by this court and by the parties so that parties are not unfairly prejudiced in the context of an alimony situation where they're trying to enforce their rights. And that's what we have here. These parties were divorced in June of 2023, and there's a history from that point forward. Mr. O'Rourke first failed to pay the alimony in transitional alimony of $1,500 a month and the alimony in futuro of $5 per month. And the significance of the alimony in futuro at $5 per month is quite important because that preserved the right for my client to file a petition later if there was a material change in circumstances. And she is obligated to enforce that right, otherwise she runs the risk of laches or waiver on that right. So Mr. O'Rourke was obstinate at every step of the way, and the record documents that. At first, he refused to pay in October and September of 2023, and we resolved that amicably, and he paid the fees. And then he failed to pay in October of 2023. And after giving him ample opportunity to correct that, he still doesn't correct it until after we file our lawsuit. We gave him 10 days, and he paid it, the first alimony, transitional alimony, but he still failed to pay the alimony in futuro of $5 for October of 23. And then he continued, failed to pay it, the alimony in futuro, in November, in December, in January, February, and March. And that's just part of his obstinance and part of his legal strategy. He his answer denied that he had made this payment. His answer said he had purged all of his default. And that was not true. And then, because he had failed to be forthright, apologize, Your Honor. Because
You said he, in his answer, didn't he acknowledge that he had made the payment late, but then go on to say that he purged because he paid later?
But he said he had purged in his answer that was filed in, I believe, December of '23. And at that time, he had not purged. He had not purged his October default, his November default, or his December default.
And that was in connection with the alimony and futuro.
Correct. He didn't purge those, and then it continued with those defaults. He didn't purge until March of 2024. And to prove our case and to prove our efforts to resolve it amicably and to show the efforts to get this done the easy way and to show his default and to show his income, we sent requests to admit. And he objected to that and filed a motion to quash. And then we filed our response to the motion to quash. And then we show up in court in March of '24, prepared to argue, and he cures his arrears that morning by handing us a check. And he also renders the argument moot by handing us the responses to requests to admit. And
so let me ask you a question then. So if I understand correctly from reading the briefs.
Oh, I meant to reserve my 5 minutes. I'm sorry. Excuse me for interrupting you, Your Honor. Excuse me.
Let's allow him to do that.
Yes. Okay.
Okay.
I apologize, Your Honor, for interrupting you, but
That's all right. If I understand from reading your briefs, if I understand correctly, on the March hearing date, the husband or the ex-husband cured himself that day of any contempt, but he did not do so until that day.
correct.
So the only thing that took place in the matter of a contested hearing on that date was the attorney fees, which were due to the wife for having brought the contempt action. Is that correct?
That hearing in March was solely on the motion to quash and our motion to deem the request admitted. And then the court subsequently set it for hearing on the attorney's fees, which the court in April said it was going to hear that, and then it said he wanted it to be briefed on the attorney's fees, and we had a hearing later in June of '24 where we briefed the attorney's fees issues. And
Okay, so the only thing ever presented to the court in this matter was the issue of attorney's fees.
correct.
And the court arrived at a fee. My question to you is, how did the court arrive at that fee?
The court failed to follow the law in applying the factors of 1.5. It did not delineate what those factors were or say how they impacted its decision. And that's one of the reasons why there was an abuse of discretion there in this case. It's incorrect application of the law because the court basically said, man, this is too much for what's involved. But that was the limit of it. And the court failed to follow the factors. It failed to follow, and then it failed to assess the evidence. The court failed to even consider the timeline, which was laid out in our trial brief below, of all the obstinance on the part of Mr. O'Rourke. And the result was unjust because it was his obstinance that caused us to incur all these attorney's fees. First, he said that they wouldn't settle. They said, we're going to contest attorney's fees. So that was one factor. Then we filed our request to admit, and they objected to that. And so attorney's fees were incurred there. And then attorney's fees were incurred throughout this process of trying to get him to do the right thing.
So let me ask you one question about that. I've read your brief and read the order that was issued by the trial judge. I haven't read the entire record. So I'm just wondering if is there anything that discusses the amount of attorney's fees in the record other than the court's order?
No. Well, there's language in the transcript of what the court said about I'm never going to approve something like this in my court, that kind of thing. But the court below doesn't give any other reasons other than he thought it was not too far beyond what was involved with how much in fees were incurred. But the burden shifted to the other side to dispute my fee affidavit. Their prima facie case arose with my fee affidavit articulating the 10 points. And then but there was no argument against my fee affidavit or the 10 points. The court just simply said it was too much. The court did point out they thought the requests for admissions weren't necessary, but it's factually driven. And we had to submit those requests for admission.
Could you have proven what you needed to prove without 86 requests for admissions?
No, because we had to have him admit the efforts that we made before and after the petition was filed. And we had to have him admit his income, the circumstances to resolve it amicably, admitted he'd failed to pay the alimony, which was due at the various times. All those were requests to be admitted. Now, the alternative would have been a deposition or testimony at the trial. But we didn't want to run the risk that we get to trial and then he disputes it somehow. And we thought this was the quickest and easiest way to do it, but instead they objected to us trying to prove our case through the simple request to admit.
All right, you have your rebuttal time. Thank you.
Thank you.
May it please the court. Good morning, Your Honors. My name is Katie Ziffer of the Williamson County Bar, and I represent the former husband, Patrick O'Rourke Jr. in this case. The trial court said it best at the hearing, both the hearings in this case, when the trial court said this is a case about $5, and it really is. The petition that was filed in this case was a petition for civil contempt only related to the $5 owed in alimony in futuro for the month of October 2023 and the $1,500 owed for October 2023 in transitional alimony. That is it. The petition does not mention any other months of missed payments. That is all that is in dispute in this case is October of 2023. So anything outside of that was not considered by the trial court because it was not in the four corners of the petition. And at the first hearing, the transcript, which is in the record, the trial court came down pretty hard on the former wife, saying that it doesn't matter what's happened any of these other months. You have to stick to what's in the four corners of your petition. And this is what I have in front of me. And the trial court specifically said in that transcript, maybe you should have amended. Maybe you need to file a different petition if you want to talk about these other months of non-payment. But the only thing in front of me is October of 2023. So this is a case about $5. Ms. Summers spent approximately $14,000 in attorney's fees and cost over that $5 that was owed to her. On October 1st of 2023, Mr. O'Rourke had that $1,500 payment due for the transitional alimony and the $5 due for the alimony in futuro. When he did not pay by October 4th of 2023, 3 days after the due date, she had her attorney send Mr. O'Rourke a letter and request payment 3 days after the due date. When he did not pay by October 12th, which was 11 days after the due date, she had her attorney file a petition for civil contempt and email it to Mr. O'Rourke. That's important. He was not served. He was just emailed a copy of that petition. And then the following day after that petition was emailed to him, he made a $1,000 payment on October 13th of 2023, and then he made an additional $500 payment on October 14th of 2023. So 2 days after he received notice, not service, but notice of the petition, he had purged himself of the contempt related to the transitional alimony. And it's important to note that according to Mr. Sir's own attorney fee affidavit, Ms. Summers had only incurred $725 in attorney's fees as of October 14th of 2023, when he purged himself of that transitional alimony obligation. Rather than dismissing her case, Ms. Summers pressed forward on the $5 that was still owed for the alimony in futuro. She had Mr. O'Rourke served out of state where he lived. And in the transcript from the final hearing, there is a misstatement about when he was served. Mr. Sir said at the final hearing, I believe that he was served on November 2nd, but that's not true. The record reflects that he was served much later in November after he had already purged himself of that transitional alimony obligation. So she paid to have him served out of state. She went on to incur an additional $13,564.50 in attorney's fees and expenses going after that additional $5 that was owed to her. Mr. O'Rourke paid the $5 alimony in futuro that was owed for October of 2023 on January 16th of 2024. Not in March, it was in January. This was another misstatement at the final hearing. So the court asked and counsel discussed, and it was said at the final hearing that that was paid in March of 2024. However, on page 5 of Ms. Summers' brief that she filed with this court, she admits that that $5 in alimony in futuro was paid on January 16th of 2024. That's on page 5 of her brief. And also on page 104 of the record, that's where the requests for admissions are. And they asked Mr. O'Rourke whether he purged himself of that $5 for October 2023 on January 16th of 2024, and he admitted it. So when we're looking at dates, that January 16th of 2024 is actually the date that he purged himself of the alimony in futuro. Again, rather than dismissing her case, now that he had purged both of the contempts that had been alleged, she sent him after that 86 requests for admissions. She sent that on January 19th of 2024. So she sent the request for admissions 3 days after he had already purged himself. There was 86 of those, and the trial court later found that those requests for admissions were, quote, excessive. The standard in this case, of course, is abuse of discretion. And the court is well aware of all the different cases about abuse of discretion, but Convalinka, specifically the 2008 Tennessee Supreme Court case, talks about that reviewing courts will only set aside a discretionary decision when the court has made the decision, that the court that made the decision applied incorrect legal standards, reached an illogical conclusion, based its decision on clearly erroneous assessment of the evidence, or employs reasoning that causes an injustice to the complaining party.
Well, let me
None of
ask you
that's
this,
true
Ms.
here.
Zipper. The first factor there you mentioned was incorrect legal standards. What standard did the court apply to get to this $2,500? Because it looks fairly arbitrary to me. I mean, I don't see any reasoning in the court's order for why the court just said, okay, $2,500.
Well, the standard is reasonableness. And so Mr. Sir did his attorney fee affidavit the correct way, where he listed out all of those rules of professional conduct, the 1.5 factors. There's 8 of those, and then the Ellis case also adds on 2 more factors that the court should consider in determining reasonableness. So the court had reviewed all of that. That had already been filed. And so the court looked at all of those 10 factors to determine what was reasonable. And nowhere does it say that the court has to list out all of the 10 factors in its order, like we do sometimes for custody cases where the court has to go through all 16 of the best interest factors. The court admittedly did not list all 10 of the factors in its order, but that was already before the court, this attorney fee affidavit. And the court seemed to give great weight to the amount in controversy. And the amount in controversy was only $5. And then the amount, according to the attorney fee affidavit, admittedly the court didn't say this, but when you look at the attorney fee affidavit, by the time he purged himself of that $1,500 transitional alimony obligation, there's only $725 in attorney's fees that were incurred, and the court still awarded her $2,500.
So I guess my question to you is, why? Why did the court do that? Because if you're saying, and I've looked at the order, and it just says it's not reasonable, but then the court lands at $2,500. That's not the amount that had been expended at the time. You just referenced that the amount expended at that time was $725. So I'm just trying to figure out, how did the court get to $2,500?
I was not there, so I can't say, and I don't know that anything in the record really reflects how the court got to that $2,500 number. I will say that at the first hearing where the court instructed the attorneys to brief the issues, the former husband's attorney made mention of a $2,500 number. And I don't know if that's where the court got it from. That was 2 months before the final hearing, but the former wife's attorney said that when he purged himself, she had probably only incurred $2,500 in attorney's fees. That's the only other place that I've seen that number. But I do think it's important to note that Mr. Sir did do a good job on his attorney fee affidavit and went through all 10 of those factors, and that is all in the record. And so we know that the court must have considered it because that was the only thing, really, that the trial court was able to consider, because no other proof was put on at the hearing. There was no witnesses. It was just the attorney fee affidavit and argument. And I do want to point out that the marital dissolution agreement says that in the event it becomes reasonably necessary for either party to institute or defend legal proceedings related to enforcement of any provision of this agreement, the successful party shall be entitled to a judgment for reasonable expenses, including attorney's fees.
What's your response to his argument that had she not pursued this, there would have possibly been a waiver?
Absolutely. She had every right to pursue it. It's not, our side is not arguing the fact that she should not have pursued it. It's solely based on the reasonableness of the fees in relation to the amount in controversy and the results obtained. She did not need to incur $14,000 in attorney's fees when he purged himself within 2 days of receiving the petition, and in fact before he was even served with the petition. And there was no proof, other than the attorney fee affidavit, there was no proof put on about all of these allegations that he was difficult to work with or obstinate. There is no proof of that. No one testified in this case.
You say he purged himself within 2 days, and you're referring to the October dates there, but he still owed that $5, did he not?
He did. He owed
Okay.
the $5. That's right. And then
Did he understand about the $5 in alimony and futuro? And looking at the transcript, the attorney that was representing him at the time started to make some statement about a lack of knowledge.
Yeah.
What do you know about that?
I don't think he understood, Your Honor. But admittedly, that's not in the record. And,
Okay, all right.
no one put on my client to testify about that. It is a nominal in futuro obligation, and I don't know that he understood, but I'll admit that that's not in the record,
All right.
whether or not he understood. And then, of course, TCA 365103C talks in that the spouse may recover attorney's fees, not shall recover attorney's fees. So even though the MDA has a mandatory attorney fee provision, which we admit is there, but it needs to be reasonable, the basis to recover under the statute is only a may and not a shall, and it must be, the statute specifically says reasonable attorney's fees. And the 2017 Supreme Court Eberbach case says that when a party is contractually entitled to recover their attorney's fees, The sole discretionary judgment that the trial court may make is to determine the amount of attorney's fees that is reasonable under the circumstances. So this is not a new issue before this court. Every time that a trial court interprets a marital dissolution agreement and awards attorney's fees, there has to be that reasonableness analysis.
How do we know that the trial judge here applied the 1.5 factors? Because there's no mention of it in the order.
I'll admit that the only thing that I can say is that he told them at the hearing, it's in the transcript, that he had reviewed the affidavit and that he found that the fees were, I don't know if he used the word excessive, but he made very clear that he was upset. I think he actually used the word ridiculous about the amount of fees that had been incurred, and he said he was quite upset about how this whole thing had progressed.
But that transcript's not attached to the order, or made part of the order, correct?
That's correct. It is, of course, on the record with this court, but it's not attached to the order itself. And then Ms. Summers cites the Keene case for other reasons to try to support her side, but I would point out, too, that the Keene case that is unreported that's cited by her says that parties seeking to recover their attorney's fees are not expected to march in a parade of witnesses to testify at length about the requested fee measures in the factors in the rules of professional conduct. Trial courts are perfectly capable of applying these factors and deciding whether a requested fee is reasonable based on their knowledge of the case and their perception of the value of the services performed. So just because Mr. O'Rourke didn't put on an expert and all of that to try to argue about the reasonableness of the fees, it doesn't mean that the trial court can't make its own determination. The Keene case specifically says that the trial courts are capable of doing that. And then the Keene case further explains that the trial court's discretionary decision will be upheld as long as reasonable minds can disagree about the correctness of the decision. In the present case, reasonable minds can certainly disagree about the reasonableness of the court's decision, but the trial court was well within its discretion in ordering $2,500 in attorney's fees over really this $5 issue. There is no abuse of discretion here, and Mr. O'Rourke respectfully requests that the trial court that this honorable court affirm the trial court's decision. He further requests an award of attorney's fees on appeal. The first basis for that would be through the MDA. The marital dissolution agreement provides that if it's reasonably necessary for him to institute or defend legal proceedings related to the enforcement of any provision of the marital dissolution agreement, that the successful party shall also be entitled to a judgment for reasonable expenses, including attorney's fees, incurred in connection with those proceedings. So upon this court hopefully affirming the trial court's order, he would be the prevailing party in defending these legal proceedings, and we would state that the attorney fee award would be mandatory in that case. And finally, Mr. O'Rourke requested an award of attorney's fees based on TCA 27-1-122 for bringing the frivolous appeal. And that will be my argument unless the court has further questions for me.
I don't see any. Thank you.
Thank you.
On this issue of trying to maintain that this matter was only about contempt, it is not, and it was not pled. Paragraph 1 of the petition for civil contempt says, said decree at paragraph 20 of the marital dissolution agreement further provides for an award of attorney's fees to enforce the terms of said decree. This was more than just an action for contempt. It was also to enforce the marital dissolution agreement, which the court in its order found in paragraph 9. Defendant breached the alimony and futuro order by failing to pay for 6 months from October 1, 2023 through March 1, 2024. But cured said arrears by March 8th. All of those arrears were cured by that date. And in our petition, we also on paragraph 5, we ask for the fees for the alimony payments that had accrued as of the date of hearing to become a judgment. And so it was clearly pled, and then they waived that issue in front of the court below when we did our briefing. It was not even mentioned that it failed to comply with the four corners of the petition. And it was, so it would not be appropriate for the court here to limit itself to just that one alleged violation, in October 2024, because we're doing more here than just seeking contempt. We're seeking to enforce the MDA. And then you made the question about, and the argument was made that there was no testimony at the trial below. That's true because we had admitted all of those facts. That was part of the evidence. And to your point, Your Honor, about, well, whether did he have knowledge in those requests to admit, he admitted that he knew what was going on. And that's the reason why there wasn't any testimony, because we all relied upon those admissions. And some of those admissions, ultimately, they objected to based on relevancy and other factors. And we didn't try to move forward and file another motion to compel an answer. We had what we needed, but we didn't get it until that morning, rendering that hearing on request for admissions moot.
Had the husband paid the $5 payments in August and September prior to the October situation?
He did, and that was pursuant to my action.
All right.
That's part of the request to admit. After she hired a lawyer, and after I sent him an email saying, you owe this, then he did pay those transitional alimony and alimony in futuro payments for August and September.
In the trial court's order, it mentions the fees were like $14,000. In your brief, you say that your client paid a total of $18,000.
Yes.
To pursue the enforcement of the MDA, which is correct.
Well, the 18 is what occurred when you add on the briefing and the argument at that hearing. And that's not part of the record right now. So we're seeking to have this remanded under the case law so that the court can make a final determination, or an appropriate, correct determination. And that would be part of the remand, because fees continue to accrue after I filed that affidavit. I believe I have 17 seconds.
Let me ask you
left.
one other thing. Is there some sort of wage assignment in effect now for the transitional alimony?
Good point, because he has corrected his behavior, Your Honor. And yes, there is he has made arrangements, and he's continued to make the transitional alimony and the alimony in futuro. And so the results of this action were to the benefit of my client, and he's now properly performing.
Before the contempt petition was filed, did he make an effort to enter a wage assignment that had not been executed and that led to these payments not being paid?
No, not that I'm aware of.
Okay. All right, thank you.
Thank you.
Thank you. You can call the next case.
In re Tony S.